Welcome to Representation Without Taxation with Jill McBride Baxter, a veteran sports law attorney for the past 30 years and certified NFLPA contract advisor.
I'm about three things: protection, advocacy, and trust.
Not only is Jill an attorney, she's the daughter of a college football coach and the wife of a college football coach, and she knows all of the issues from all angles. This is Representation Without Taxation, a one-of-a-kind show featuring critically relevant material for contract employees and...
A very important case, House versus the NCAA, was not certified by Judge Wilkens. This is a concern for the NCAA, and after listening to the hearing, I'm here to explain exactly what happened. Often in my life, my husband comes home when we start talking about things, and I realize as a lawyer that there's things that I understand that maybe the general public doesn't exactly understand what's going on. To explain House versus the NCAA is the plaintiffs complained that the rules prior to 2021 didn't allow athletes to make money off their name, image, and likeness. As we all know, that has changed as of 2021. This case has to do with the damages that student athletes had prior to 2021. So if you currently are a student athlete, if you were a student athlete prior to 2021, actually between the time, I think, 2016 to 2021, then you had damage, meaning you weren't allowed to use your name, image, and likeness. And so the NCAA got sued, and they got sued under the antitrust laws. As I was sitting there talking to my husband, he's like, "What's an antitrust law?" And I basically tried to explain to him that an antitrust law is basically you can't do things. A big business cannot do something that's anti-competitive and prevent someone from making money off their name, image, in this case, their name, image, and likeness. In big business, it's like monopolies or price fixing, those types of situation. What's that mean is that one company, in this case, the NCAA and the conferences, kind of all colluded to say, oh, by the way, all student athletes, you can't make money off your name, image, and likeness. And so when a big company does that, it is a violation of the antitrust laws. And the NCAA also put in some rules that even though they were allowing name, image, likeness, they started to restrict it and were going to judge certain NIL rules, NIL deals with athletes, and maybe could deem that those were not an accurate amount of their name, image, and likeness. So the plaintiffs' attorneys and the defendant, in this case the NCAA is the defendant, they agreed to a settlement in the House case. But before a settlement can occur in a class action antitrust case, you have to take it in front of a judge. In this case, Judge Wilkens, which is a U.S. District Court in the state of California, northern part of California, is the judge that had to, in a sense, rubber stamp the settlement. Well, guess what? She didn't. The reason why she didn't is pretty simple. She told the plaintiffs and the defendants that you now agreed to, yes, compensate these particular individuals for the damages that occurred between 2016 and 2021. But they went on further to restrict and further define how they were going to, that had to do with the NCAA and conferences, so to speak, restricting third-party collectives from certain kinds of deals, because there was language in there that actually restricted and was going to sort of look over any NIL deals done by third parties. She basically said that concern with the process was that this position, this pay for play, is prohibited under NCAA's and NCAA rules, and that prohibition has been upheld by various courts. But under the settlement, athletes would have to report NIL payments of more than $600 to a clearinghouse that would be established, and then their deals would be subject to review, with the goal being the prevention of pay for play and deals that pay amounts above market value. And athletes who have questions about the permissibility of their agreements would be able to seek advisory opinions from an enforcement group. If the enforcement group sought to sanction an athlete because of a deal, the athlete would have the ability to bring the matter to an arbitrator. Wilkens' concern, the judge's concern about this, is a potential killer. She said that a source familiar with the process who spoke on the condition, I've seen all of it, but it doesn't sound good to me, that's for sure. She said Wilkens raised questions with how a booster providing pay for play would be defined under the proposed setup. And today's third-party donor to a collective is tomorrow's booster, which means that now they can't do it anymore. And she basically said, if a fan gives $1 million or gives them a truck, is that a booster? I don't know. Is that a collective? I don't know. Is having a winning team a valid business purpose? Discussing the prospects of schools directly paying athletes amounts at their discretion within the cap for their NIL, Wilkens said wouldn't that be pay for play? I turn back to all of you to find something workable, consistent, enforceable, and fair. She did not like any kind of a restriction on the ability for a student athlete to make money from a third-party collective, because under the current rules, anybody possibly donating to collective would, quote, end up being a booster. And also, she was concerned that that these were quite strict rules, and she questioned whether current athletes with certain payments, whether or not those payments would be taken away and they wouldn't be able to receive those any longer. And in quote, she says, taking things away from people doesn't work well. So I don't know how the NCAA, and this was the major sticking point with the whole settlement with Judge Wilkens. The other major sticking point was the way this is set up currently is this settlement would also be enforceable against future plaintiffs. This lasts for a 10-year period, but her point was, if there's a 6-year-old right now who then would be a student athlete at 16, are they subject to this settlement? And the way I understand it is, it must be that these plaintiffs that don't necessarily know they're even have the viability of making money off their name, image, and likeness are not being represented, and it would be a conflict for the same attorneys to be representing the 6-year-old who, by the way, doesn't even know that they have this ability yet, And she had a lot of problems with this settlement applying to a potential student athlete 10 years from now, which is the injunction part of it. She kind of basically told them, focus on the current damages with the current pool of athletes that we're talking about, which I find that to be problematic, because one of the things that the NCAA's goal was with this whole settlement was to try to prevent future lawsuits. She did not like that this was going to be enforceable against plaintiffs who, don't even know that they have the possibility 10 years from now because of the 10-year period that they put this settlement in. So if you're wondering what is going to happen next, basically what the judge told the plaintiff's attorney and the NCAA is you have 3 weeks to change your agreement. And she specifically told him, make sure that you focus on damages, and in a roundabout way, you can't have any restrictions on how a particular student athlete receives NIL money from a third party. And so my message to everyone is, if you're a coach right now and you have players coming in and saying, hey, I want more money. First of all, number one, you are not somebody who is going to be able to provide any money in exchange for the use of their name, image, and likeness. That is not a coach's job, and that is not a coach's duty. So that is outside of them, and therefore everything should be handled outside of the football office at this point. If there's a third party or collective that your player wants to get in touch with and they choose to give that particular student athlete money, I think you ought to really stay out of this. Why? This judge is saying you cannot put any restrictions on it. That doesn't mean that anybody has to give a player anything, or a student athlete anything. As far as, what should administrators do? What should student athletes do? I think you got to sit this out and see what's going to happen in 3 weeks. If they completely change the language dealing with collectives, I don't know if the NCAA is going to be willing to settle, and or they just settle it on here's what the damages are. And then she was concerned about the language in what was going to be sent out to athletes through 2016 to 2021 to make sure that the language in the claim forms were accurate. She didn't seem to like that either. So there was a lot of work that was going to have to be done between the plaintiffs and the defendants. The judge also didn't like the $20 million cap on what a school could pay out of revenue. Of course, that's something you can either do or not do. So it didn't seem to me like she basically is saying under the antitrust laws, you can't restrict anybody's right to make money off of their name, image, and likeness. So they're going to have to go back to the negotiation table and see if they can come up with a compromise. Otherwise, this is going to go to trial. What happens if it goes to trial? If it goes to trial, there could be treble damages, which would be 3 times what this particular case was settling for. So I don't really know what's going to happen, but currently, because of the case in Tennessee where the NCAA rule about pay for play and collectives was really stayed and not going to be enforceable, so to speak, then I just would sit tight and see what's going to happen, and just hopefully you win all your games. As far as to my coaching clients, good luck this week. Thank you so much for allowing me to serve you and to be your representative. And if you are a coach out there and you're looking for representation, please give me a call, and I can or set up a meeting with me and we can discuss representation. I think it's very important that everyone has representation, particularly with their contracts, and you should have an attorney. I'm one of the few agents/attorneys who does a flat fee for people throughout the year for 1 year. And just go to my Calendly link on my website or in the show notes, and I look forward to talking to you. Have a great weekend, and I hope everybody has a winning season. Thank you for listening to this episode of Representation Without Taxation. Simply stated, I am always and forever about 3 things: protection, advocacy, and trust. To learn more about my fair fee structure, please visit my website at jillmcbridebaxter.com. If what we were talking about strikes a nerve, please subscribe and definitely share it. Until next time, it doesn't matter what the plan is, as long as you have one.